Good evening and welcome. I'm John Abel from the Historical Association, and I'm here to welcome all of you to the final installment of our third Thursday lecture series for the 2024 season. Tonight we have Mr. Michael Muth with us, who probably does not really need an introduction, but it is my job to introduce people, so he's getting one. He is well known as a long-serving public defender here in Monroe County, and for 2 years served as a president of the Public Defenders Association here in Pennsylvania. He was a district judge in East Stroudsburg, retiring after his third term. And also, I remember very well 5 years ago in 2019, as part of our third Thursday lecture series, when he did a very informative and interesting presentation for us on the aircraft of World War I and the Lafayette Escadrille, and that was just absolutely wonderful. Tonight he will speak to us about the right to a free lawyer and the concept of the public defender. Please welcome Michael Muth.
I'm just going to add one thing to all that. I'm now a district attorney, an assistant district attorney. I was hired by Mike Mancuso after retiring, and after 3 months of retirement, I said that's about 2 months too long. So now I'm here. What's the phrase? History's written by the winners. Well, it was a little while ago. I was talking with Julia Burns, and after I'd given my previous lecture, and I said, well, maybe somebody should give one about the public defender office. And she goes, well, yeah, who? And I thought about it. I said, oh, crap. So you got me. The advantage is, if I'm going to give this speech, I can tell you the real history of the Monroe County Public Defender Office from my point of view. And no matter what anybody does after that, they still got to always come back to this one. So with that in mind, for some of you here, this is going to be boring because I'm going to talk a little bit about how we got to the Public Defender Office before I get into the actual history of Monroe County and the Public Defender Office. So with that in mind, let's see if I can do the clicker. Real simple. The U.S. Constitution has something which seems simple, doesn't it? In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel. So what does that mean? Well, if you want to be like the current Supreme Court, you go back to what it meant back then. And all that it meant back then is if you could afford a lawyer to go in, they couldn't throw him out of the courtroom. That's all it meant. The idea of a free lawyer, if you couldn't have one, if you couldn't afford one, that was a joke. All that meant was if you could get a lawyer to go into court with you, the judge couldn't throw him out of the courtroom. That's what it meant. So, with that in mind, there's a couple cartoons in here. I probably can't read them though, but they're really funny. One of the things that inspired me to get into the public defender office and do criminal defense work was John Adams. Before he was the second president of the United States, John Adams was a very famous lawyer in Boston. And in Boston, during the Boston Massacre, he was a very prominent, what would you call them, Sons of Liberty in that whole crew. And then when the British soldiers shot and killed some of the patriots during the Boston Massacre, that's what it was called by the Patriot papers, nobody would represent the British soldiers. It was just too hot to handle. And most of the good lawyers were all patriots, and they didn't want to do it. And there was plenty of people, in what they called the Queen's Bench or the King's Bench back then who would do it. But they'd prosecute them, but they wouldn't defend them. So these guys were looking at the death penalty. There were, I think, 7 of them. Were looking at the death penalty for shooting into the mob. That's what the British called them, a mob. And finally, John Adams said, well, if we're going to have a system of laws, we got to have it. It's got to be fair. And if these guys have to go into court against a trained lawyer, that ain't fair. So, okay, fine, I'll do it. So he charged them for doing it. So he wasn't free, but he represented them. As a result, I'm trying to remember, 4 of them got acquitted, 2 of them got convicted with minimal punishment, and 2 of them had their thumbs branded. They were the ones who it was determined did the final actual shooting that killed people. John Adams, as you can see in the little quote here, he talks about how it was the best thing he's ever done, the purest thing he's ever done, doing something just for the benefit of a system, a justice system. Now having said that, John wrote in his memoirs how pissed off he was because the captain who he represented and who he got off completely welched on the deal and never paid him. And it got to the point where John would see him walking down the street, and John would walk across the street to say, where's my money? And the captain would walk over onto the other side of the street. So unless you had somebody like John Adams who's willing to take a flyer on something famous that he thought he could, or something idealistic, you're hosed. The colonies adopted different systems, and this was surprising to me. Back in 1776, 7 of the, back then they were colonies, I guess, still are states, provided a guaranteed right to counsel. Now, it was only for certain cases, and there are all sorts of restrictions. But the beginning of the idea that if you can't afford a lawyer, we'll get you a free one, started way back in 1776. Pennsylvania had a free lawyer for capital crimes, way back in 1776. New Jersey and Connecticut had a free lawyer for any crime. But up until really the 1900s, the early 1900s, everything was left up to the states as to whether they were going to give you a free lawyer or not. This is just some language from Supreme Court in Indiana when they decided that someone had a right to a free lawyer in a criminal case. And it's high-minded, and it shows the importance the system has in having a lawyer represent everybody who comes into criminal court. This is all I'm talking about tonight is criminal court. We're not going to talk about whether you have a right to sue somebody and you get a free lawyer for that. This is if you're going to take somebody's liberty away. Before you can do that, you got to bring him into court, and he's got to have a chance, which means he's got to have a lawyer. So, the development of the right to counsel, free counsel we're talking about now, we'll first talk about before the case, the famous case of Gideon versus Wainwright, and then we'll talk about Gideon and its aftermath. So before Gideon, and you still had 2 systems. I'm not supposed to move, am I? Okay. For the lawyers here, you can fall asleep for a second here. There's federal crimes and there's state crimes. Federal crimes are tried in federal court. State crimes are tried in state courts. And the federal has their own system and their own rules, and the states have their own system and their own rules. Every once in a while, there were some, the federal would say you got to do this everywhere, but most of the time, federal followed its rules, states followed their rules. Until 1938. And in 1938, the issue came before the Supreme Court in a case called Johnson versus Zerbst. These were 4 Marines who were on shore leave and realized that their salaries weren't quite enough for shore leave. So I don't know exactly how they counterfeited them, but they each counterfeited 4 $20 bills and figured they would have a hell of a night. Well, it did. Somehow they got caught. They were caught, arraigned, put in jail, tried, and convicted within 4 days. And never had a lawyer. And were sentenced to 12 years in prison, which I guess meant they avoided World War II. But went up to the Supreme Court, and the Supreme Court looked at that and said, nah, that's just not right. That's not fair. How are they going to have a fair shot at things if they don't have a lawyer and you're going to ram it through in 4 days? There's something just inherently wrong with that. And what was inherently wrong can be stopped as long as they had a lawyer, because they would know where to step in, what issues to raise. So they said, anytime somebody's brought to trial in federal court, only federal court, because we're not going to make the states do what we're doing. It was a big thing back then. But every time you're charged with a crime in a federal court, you get a free lawyer as long as you're indigent. Okay? So that seems simple enough. We're in the 1930s, and if you're charged with a crime, you get a free lawyer. But only if you're charged with a big enough crime, a crime that's in federal court system. So if you're charged with shoplifting at the PX, that's a federal crime. If you're charged with murder in the state courts, that's a state crime. You don't get a free lawyer for that. But for the federal crime, you would. Slowly, the states had to start dealing with this issue because it was coming up more and more, where different pressure groups were representing people for free, saying these people were convicted, they shouldn't have been convicted, they didn't have a right to a lawyer. And one of the first cases that came up was in 1932, and it was in Powell versus Alabama. This is also known as the trial of the Scottsboro Boys. I don't know if anybody's ever heard of that before. But the Scottsboro Boys were 8 young African-American men in Alabama who were charged with the rape of 2 white women in the early 30s. These were the 2 women who they were supposed to have raped. I say supposed to have because one of them took the stand and said she was not raped. And the other one said, yes, we were. And so it went back and forth. But this is 1930s in Alabama with white woman claiming she was raped by 8 black men. You can guess who won. They were all convicted. But they had a trial. This is them going to trial. That's the Army marching them to and from the courtroom. And that's the Army sitting with their lawyer, Sam Lieberman, or Leibovitz, I forget, Lieber something. As he was described in the newspapers, a Jew lawyer from New York. And you can there see the Army men protecting him from his clients. Anyway, he went, took him to trial, got convicted, went to the Supreme Court and said, hey, these guys should have had a free lawyer. You know, they were poor, they're charged with murder, this is real stuff. And, you know, in federal court, they'd get a free lawyer. Why not in state court? Went up to the Supreme Court, and in Powell versus Alabama, they said, we don't like to tell the states what to do. Sound familiar? But there are some things we just got to tell them what to do, and here's one of them. If you're going to give somebody the death penalty, a capital case, due process requires that the states have to give them a free lawyer if they're indigent. Okay, so the key words, the states have to, free lawyer if they're indigent. Free lawyer and indigent are the 2 bugaboos that we're going to be talking about mostly from now on. So they got a free lawyer the second time, and one guy got acquitted, and the rest got convicted. Went up to the Supreme Court for a second time because Alabama had a system that said, okay, we'll give them a free lawyer. And they want a jury trial, we'll give them a jury. Of course, they just didn't let blacks on the juries back then. So it went up to the Supreme Court. The Supreme Court said, nah, you can't do it that way. You can't systematically exclude minorities from jury pools. So it went back a third time, and then I think only 4 of them were convicted. Meanwhile, these guys are in jail the whole time. So the aftermath, we know that now in state courts, if you murder somebody, you get a free lawyer. But that's it. If you're in the state court system, unless you murdered him, you're stuck. You got to do it on your own. That's the grave of the last member of the Scottsboro Boys. You can tell how well kept it is, right? Most of these guys spent the rest of their lives in prison. One guy was shot and killed in prison. It is a horrible, horrible situation. And it baffles me that there was a musical on Broadway called The Scottsboro Boys. Big smiling faces doing a dance number while they're going to prison for the rest of their lives if they're lucky. This isn't the first time where I'm going to make fun of the entertainment industry tonight, but it's one of them. So we've got Johnson versus Earps, federal court, any crime, you're poor, you get a freebie. State court, if they're going to kill you, you get a freebie. Remember, these guys were not charged with murder. They were only charged with rape. But back then, it was the death penalty for rape. So you can see it's kind of building to the idea of let's give poor people charged with a state crime a free lawyer. Until the case of Betts versus Brady came about. This is my favorite slide. It's Tom Brady and Mookie Betts. I just couldn't figure out a way to flip the picture. But that went up to the Supreme Court. And in Betts versus Brady, the Supreme Court says, no, we're not saying you have a right to a free lawyer. We're leaving that up to the states. Again, it'll sound familiar. So before Gideon, if you're charged with any crime in the federal system, free lawyer if you're indigent. If you're going to be put to death, death penalty case. In the states, free lawyer if you're indigent. Anything else, hands off. We, the Supreme Court, are not going to do a thing. That's up to the states. So the way the states reacted, and this surprised me a little bit too, by the 1950s, only 8 of the 48 states back then didn't provide for a free lawyer in some fashion. And you see the ones there, the different things. California, New York followed ZERPs. That meant any crime, if you're poor, you get a free lawyer. In 35 states, the legislature made it an obligation of the court to appoint counsel in non-capital, beats non-death penalty cases, to varying degrees. In Pennsylvania, the rule was, well, if you can show us that during the trial there was some sort of unfairness, then we'll give you a free lawyer and you can have your trial all over again. So it wasn't one of the more liberal decisions back then. Well, that was obviously a recreation of what happened. That is the Bay City Pool Hall, or the Bay Harbor Pool Room. It was in a town in Florida. And somebody broke into it, and as you can tell in the video, broke into the jukebox, which took quarters, nickels, and dimes, and the cigarette machine, which took quarters, nickels, and dimes, which Clarence had 2 pockets full of. That's Clarence, during the better times, shooting pool in the Bay Harbor Pool Room. That was after he got out, I think. So Clarence was tried, convicted for felony theft, and was sentenced to prison in Florida. Clarence, when during his trial, said, not to put it, he didn't say, I ain't got no lawyer, but it was pretty close to that. He said, Constitution gives me a right to a lawyer, give me a lawyer. And the judge said, well, Clarence, it's not a death penalty case, so no. Clarence's response was to write an 18-page letter to the United States Supreme Court. This is just page 1 of it, which in 18 pages, he says the same thing. I'm indigent. I'm charged with a crime. I got convicted. I needed a lawyer. I wanted a lawyer. They didn't give me a lawyer. Now, the Supreme Court takes this case up and says, okay, we'll hear this case. This sounds interesting. We haven't made a decision on free lawyers for a while. So if you think Clarence Gideon got to go to the Supreme Court and argue his case, you're wrong. The Supreme Court doesn't want an idiot like Clarence Gideon up there saying what the law should be. So they appointed him a lawyer just for the purpose of arguing whether he had a right to a free lawyer or not. So he got a free lawyer to argue he should have had a right to a free lawyer at his trial. Now, this kind of gives you a hint as to where they were going. They appointed a guy named Abe Fortas. Abe Fortas was appointed as a United States Supreme Court Justice 2 years after this happened. So it's kind of a ringer. So, and the other lawyer they gave him, a lawyer who was good with state law, was Fred Turner. They argued the case before the U.S. Supreme Court. Most of the states, even states that had adopted a policy of free lawyers if you're charged with a crime, as long as you're indigent, even though that was the position in their state, most of the state's attorney generals came in and said, don't make this a state law. figuring they could change things in their own state if they wanted to. The Supreme Court said no. It said, look, don't you think it makes sense if we've got the prosecution of the case having a trained lawyer to prove their case, that the guy who's supposed to respond to that should have a lawyer too, just to keep things kind of even? So they overruled Betts versus Brady, and they said we were wrong when we decided that, and said from now on, if you are indigent in state courts, you get a free lawyer. Again, we're only talking about crimes now. We're not talking about parking tickets. We're not talking about civil lawsuits. We're not talking about divorces. We're only talking about people charged with crimes that can go to jail. And they deemed it as being fundamental to a fair trial. So the states were furious about this because they didn't want the Supreme Court telling them what to do. And the majority of the argument that was raised was, how can we afford this? You know, the idea of a free lawyer, yeah, it sounds great, ethereal, you know, really great. Who's going to pay for it? And they said, that's your problem. And that's our problem now. Gideon was retried and somehow was found not guilty. Now, Abe Fortas knew when to get out. And he turned to Fred Taylor and said, good luck, Fred. I did my job. And Fred did his job. Again, Abe Fortas was appointed to the Supreme Court shortly after all this happened. Now, when we were in the public defender office, we made up T-shirts that basically had the get out of jail free card with the guy from Monopoly, and we would wear that when not in court, but when we went out and did stuff. Well, there's Clarence Gideon's gravestone. The ACLU wanted to make a big monument. This is back in his town in Missouri, his hometown in Missouri. And they wanted a big monument, like, look at this, what this man did. It was wonderful. He was described by the local sheriff as a no-good punk, which is probably pretty accurate. And so they eventually compromised on a small stone that said, each era finds an improvement in law for the benefit of mankind. Nothing about how it was Clarence's idea. Well, at least we don't have dancing people. There was a book called Gideon's Trumpet, written by Anthony Lewis, the guy who was on one of the videos. And eventually they had a movie. I think it was a made-for-TV movie, actually. So I shouldn't have said Hollywood. But they had Henry Fonda play Clarence Gideon. It's pretty good likeness, I thought. The state followed Gideon just like you'd imagine. By then we had 50 states, and we had 50 states doing different things. Some already had a system in place. They said, hey, cool, we don't have to worry about it anymore. Some had it as a statewide public defender. They would have like 8 public defenders, and they'd represent everybody charged with a crime in the entire state. Some had a county system where each county would take care of the public defenders. Ohio has county public defenders and state public defenders. Real big crimes, we'll give them to the big boys, the state public defenders. Your typical break-in robberies, we'll give those to the local public defenders. Some public defenders are part-time, some are full-time. Some states said, well, we'll keep doing this, but we're not that big. We'll just appoint somebody when we need them. So Art remembers this. Judge looking out into the audience sometimes when the public defender wasn't around, and he'd go, Attorney Zulick, come on up, meet your client.
Well, that
not quite.
A couple years before. That was Ed Krautz here.
Yes. So, let's start getting a little more local now. How did Pennsylvania respond to the whole idea of the free right to a free lawyer? Well, it took them a while, but in our Constitution it says in all criminal prosecutions the accused hath a right to be heard by himself and counsel. It didn't tell you much, does it? We already know what basically that means. You can't throw the lawyer out of the courtroom. Was it 4 years after Gideon was decided, we passed the Public Defender Act. So you can see how quick we responded to things. And it became effective on January 1st of 1969. And it said each county is to appoint a chief public defender. That is the only county officer, row office, if you want to think of it that way, that's appointed by the commissioners. All the other ones are elected. We've had 5 chief public defenders in Monroe County. Started with Ronald Viken, me, Wes Niemashinsky, Jim Greger, and the current chief public defender, Jason LaBar. Just don't read the statute. It just says the public defender's got to represent people in these following cases, and it lists 12 of them. I think it's 12. Charge of the juvenile delinquency, similar, like if they're an adult, it'd be an adult crime, so juveniles get it. And it's different stages of the procedure. It says you don't need them just at trial, you need them really at the very beginning. And here's the kicker, number 11. In any other situations where representation is constitutionally required, which in Monroe County meant anytime a judge wanted you to represent somebody, it became constitutionally required. So we would end up occasionally doing custody cases. That didn't happen often. Protection from abuse cases, we would do those. Or some other. Basically, whenever the judge needed somebody, they would just ask the public defender office to step in. So what's missing?
3 teeth.
Doesn't say how you're going to pay for it. I couldn't get those. I don't know. There's a way to have them scream out, "Show me the money," but I don't know how to do that. By the time the states had all done something with regard to Gideon, 16 states, it was completely paid for out of the state budget. One state had an alternative revenue source. I don't know what that was. Private funding, probably. 100% local government funding, 5 states. And then 28 states had a combination of state and local money coming in. But again, notice the Supreme Court didn't say how much you had to pay, and it didn't say how you get to pay. You know, how you get the money to pay for them. They left that up to the states. The states were not happy. Bill, that one came up better. If you want justice, it's $200 an hour. Obstruction runs a little bit more. So, we don't know where the money is, but we know there's a system for it somehow. The other thing that's missing is indigency. I can't afford a lawyer. They keep using the phrase indigent in Gideon and all these other cases, but rarely ever define it. There is no definition of indigency in the Pennsylvania statutes or in the rules of criminal procedure. It does use phrases like lack of sufficient funds, doesn't say what that means, inability to get sufficient funds, and I think that means something other than robbing a bank, without financial resources, otherwise unable to employ counsel. Still doesn't tell you too much. I had a guy who was charged with driving under the influence of alcohol here in Monroe County. He was on a bender. Unknown to me, 2 days before he was arrested in Monroe County, he was arrested in Northampton County for driving under the influence. He met all the requirements for us. We worked out a guilty plea for him, getting him ready for sentencing. And he goes, "Well, how's this going to affect my case in Northampton County?" I said, "What case in Northampton County?" He said, "Well, I've got a drunk driving in Northampton County. It happened 2 days before this." I said, "Okay, well, just give me your lawyer from Northampton County." "Oh, they didn't give me a lawyer." I said, "What do you mean they didn't give you a lawyer?" Then I called down Northampton County. I said, "You didn't give him a lawyer?" They go, "No, we didn't think he was eligible." I said, "Well, we did." And he said, "Well, we disagree." I was able to talk Mark Love, a local lawyer, into doing something for free. I said, "Would you take this up? And, we got to settle this. This is just stupid. You can't be kind of a virgin. You can't be kind of indigent. An indigent in one county and not indigent. And that doesn't make any sense." So he took it up to the Superior Court and said, "You're right, it doesn't make any sense, but we don't know who was right, whether it was Monroe County or Northampton. So we reject your appeal." There still is no statewide definition of indigency. There still is. We had a meeting one time with a state Supreme Court judge when I was president of the state association. And we were talking about things statewide and issues and stuff. And he said, well, you said there's a problem with determining indigency. I said, yeah. I said, well, don't you just apply the state guidelines? And we looked at the judge and said, oh, you poor dummy. I said, there's no state guidelines. He goes, what do you mean there's no state guidelines? And he was a corporate lawyer, and he couldn't imagine that there wouldn't be state guidelines. Neither could we, but he didn't get it changed either. So, you're good. The idea of you can be kind of indigent in one county, not indigent in another county, it doesn't make sense to me. And yet the state has yet to do anything as far as that's concerned, other than use those very vague phrases of, unable to raise money, and the ones that I listed earlier. Other states have done things equally weird. Some states have an application fee. Now, you're applying for a free lawyer because you can't afford one. And what's the first thing they ask you? Well, give us some money. What's the phrase? I ain't got no money, honey, right? So, not a smart decision. Or a sliding scale. That's the sort of indigent. So you make only $1,000 a month. Okay, 100 of that's going to go for the free lawyer reimbursement. Family money. Well, your old man makes money. Make him pay for the lawyer. During the time that I was in the public defender office, we represented one state senator's son, 2 judges' sons, and somebody else that was loaded. I forget who it was, but it was just because the old man wasn't going to pay for the free lawyer or pay for a lawyer. Go get that free one. Time payments. Judge Marsh thought of that for a while here in Monroe County, where I said, okay, well, yeah, you can get a free lawyer, but, when you're convicted, because of course you're going to get convicted, well, you can start reimbursing them as, added on court costs. So you're indigent until you get convicted, and then we'll get you. None of these solve the problem, and all they do is throw up barriers to having poor people being brought into court saying, I can't afford a lawyer. Did you apply to a public defender? I didn't have the $100 to apply, or whatever of the rest of these. This is a quote from a decision by the judge up in Luzerne County after the Kids for Cash scheme was starting to be discovered. And one of the things was that none of them had a lawyer. And they were talked out of having a public defender by being told, well, this will work a lot easier for you if you don't have a lawyer. And that was the judge's response. It's pretty strong language. Even when resources are scarce, constitutional obligations must be afforded a priority. Anything less would offend the sacrifice of those who created and defended our constitutional democracy. So he's basically telling the legislature or the county commissioners, suck it up. You've got to pay, and you got to pay real money. That's one judge in one county. How about in Pennsylvania? Just generally, how are they funded? There's no state legislation to fund a county public defender office. None. It's all on the counties. How the counties do it, that's up to them. But the state did not get involved until 2023, when Governor Shapiro said he appropriated, was it $47 million for indigent defense. That wouldn't even run some of the offices. I mean, it's better than nothing, but not a whole lot better. There's only one state left that doesn't provide for any state funding. And currently the states and the counties are defending a variety of lawsuits filed by, among others, the American Civil Liberties Union, claiming that the insufficient funding and the lack of a uniform state guidelines when it comes to funding for public defenders and for caseloads and everything else denies them their constitutional rights. It goes right back to Gideon. and says, okay, you got a right to a lawyer, but it's not going to do any good if you can't get a good one, or if you can't get someone to pay for it. Monroe County's response, once they got over all the humps, you're probably wondering why the typewriter's there. It took a while. Initially, the public defenders had to practice out of their own private offices because they were only part-time. So they didn't want the defendants coming in and dirtying up the courthouse in a public defender office. They just told the first two public defenders, just do it in your own office. And here's the salary we're going to give you, and have a good life. And then the act got passed, and the public defenders did a little bit of lobbying. And I lost the letter that was written by Ron Viken. This is a letter to the county commissioners that it was like 3 pages. It went something like this: Dear commissioners, thank you so much. We now have our own office. This is wonderful. We no longer have to have clients coming in and out of our private office. Oh, and you gave us a secretary, so we don't have to have our own private staff be diverted from things. This is great. You gave us a typewriter. This will help. We don't have to handwrite our clients' paperwork anymore. The typewriter is terrific. We don't know how to thank you. You gave us so much here, and we really hate to do this, but we need more. We need the following. Item 1, could we have a desk to put the typewriter on? Item 2, can we have a chair for the secretary to sit in? And I think that embarrassed them enough. So but it was tight getting money from the county commissioners. One of the county commissioners I talked to after he'd gotten elected, he was getting his feel for what was going on in the courthouse, and he comes into me and says, "Can I talk to you for a few minutes?" It's like, "Yeah, you're my boss. You send me the money, so you can talk all you want." He says, "Well, let's see if I got this right. We pay police to arrest people. We pay a judge to convict people. We pay a jury to come in and convict people. We pay the sheriff to house people who are convicted. We pay jail guards to guard the people who were convicted. We pay a probation officer to put people in jail and to make sure they do what they're supposed to do when they get out of jail." I'm going, well, I can see where this is going. I sure don't like it. He goes, "And then we pay you to screw it all up." And I said, "Yeah. Do I have any control over this?" No. And he was the best commissioner we ever had from my perspective. He said, "Okay, if I have no control over it, just show me the numbers and I'll give you what you want." We're pretty good. He was unusual in that regard.
Who was it?
And I won't tell you that one. Mostly because I don't want to tell you about the second one. It was Stu Pfeiffer. He's dead now, sir.
Oh, really?
Yeah.
That's a surprise.
Another one whose name will remain nameless, his comment to me was, that's the first one. He said, "How does it benefit me to fund this office? There is no political gain in it for me to increase your staff, unlike if I did the DA's." Now, in fairness, the county was just as stingy with the DA's office. Well, almost as stingy. There was a big difference in salary. They got paid $500 a year more. That was it. During the whole time I was a public defender, the DAs and myself, the chief DA, would go in at budget time, united in what we wanted and in what we were trying to get. Because there really wasn't a big argument about it, at least among the two sides that would be fighting in courtrooms. Staffing. After Gideon, there were two part-time public defenders. I don't know if I thought I did pictures of them, but maybe I didn't. The two part-time public defenders were Jerome Cheslock, who later became a judge, and Jim Marsh, who later became the district attorney. They had no staff and no office. By 1988, we had 5 attorneys, 1 full-time, 4 part-time, 3 office staff. We had a volunteer detective. Commissioners wouldn't pay for a detective, but he was finishing up his degree, and as his internship, he said, "What if I become a detective. Works for us. So that was our first detective, a freebie. And we had an office. By 2005, we were up to 9 attorneys. You notice the big difference is we got more and more full-time attorneys. Office staff, we got a paid investigator by then. And instead of the 1 or 2 secretaries, we're now up to 4. When I left that was when I left in 2005. Recently, as of 2024, I don't have the number of attorneys anymore, but I think it's like 11. Is it like, Jason, was it 3 part-time maybe, something like that?
There are 3 part-timers.
Yeah. And their office staff, they have numerous investigators, paralegals, and numerous secretaries. So in terms of, over the last 40-some years, they got a whole lot more than it. It's still probably not even nearly enough. Yeah, okay. Yeah, it's at 13. There. I knew I had a slide on that. Take a look at the salaries. In 2005, when I left as chief public defender, I was paid $45,000 a year. The current chief public defender is full-time, gets paid $130,000 a year. A full-time public defender would get paid $32,000 in 2005, and now they get paid $72,000. Part-timers, the salaries varied. It was in the 30s, though, if I remember right, and now it's at $53,000. So here's our offices, kinda. The office on the left is a stock picture out of Photo Bucket or something like that. Unfortunately, everybody didn't have cell phones when we got started, so there was not a lot of pictures. What we did have, though, was one big office with a table in the middle, and that's where you would do all your work. So anyway, that was what our first office looked like. That was on the 2nd floor, and it's now used as a jury room. Then they started building onto the courthouse, the middle section, and they moved us because the DA's office had to move, and the DA didn't want to have to go up to the 3rd floor, so the DA went to the 2nd floor, and we, of course, got to go up to the 3rd floor. Now, I was complaining about how we should be able to stay on the 2nd floor, but, that kind of stuff. And Judge Viken said, "You're going to like the 3rd floor." I said, "I am." He goes, "Yeah." So he took me up to the 3rd floor, and that's Alan Young, showing how the courthouse bell, after it had gotten all fixed up. Anyway, you can see that it's not there anymore, by the way. There's a good picture. 1984, we were we started to have private offices and a big room in the middle where the secretaries were. And you can see 2 people there diligently getting ready for one of their joint trials together. That's me on the left when I had hair and no beard. And that's Art Zulick when he had hair. By 1997, we had moved into what was called the old commissioner's office. And that's in the basement of, again, the middle building now. And that's some of the staff there. But you can just see, it looks like a regular office. There's little sectioned off offices, big area. And by then we had about 8 or 9 lawyers, and we had 3 offices to put people in. And Jason Leon said, "Well, let's just section this off." So we went to the commissioners and said, "Can we section this off?" And they said no. And, we asked again, and they said no. And on a Saturday, Jason came in with all his tools, and he and me and somebody else sectioned it off so we could have more private offices. It wasn't anything major, but about a year or 2 later, one of the commissioners came in, and he looked at it and he says, "Oh, this is really nice the way we sectioned this off." I said, "Sure is." And I never did find out. So anyway, that's what the office was then. There you can see that Jason and Judge Germano, Brian Germano, in what obviously is not a staged photo, we're looking at a transcript. Until now, the current office is located in the old Shearson building, the one on the corner of 7th and Main Street, up on the 3rd floor. It's huge. I tried doing a video. I failed. So that's all we got to do is the door on the outside. But they've all got their own private offices, and the digs are really pretty nice. Some of the first in the public defender office. The first public defender was Jerome Cheslock. The first woman public defender, and that was a big deal back when she was appointed, was Ann Tarakia. The first full-time public defender was Janet Jackson. First full-time chief public defender was Wes Niemaszynski. The first one of the public defenders to go onto the bench was Judge Viken. The first detective, the guy who did it for free, was Lenny Semino. The first office manager was Gene Cotter.
Can you do the voice?
What?
Can you do the voice?
Which one of Gene?
Beans.
Sir, something like that. She was in her 70s, I think, when she was working for us.
She was my neighbor up on top of the hill.
Yeah, she would, and she'd get calls from the judge's secretaries. We need a public defender in the courtroom now. And the one secretary she liked, and she'd say, all right. But the other one, she goes, my men are busy. Boom, and slammed down the phone. She goes, what are they going to do to me? I'm 70. First person from Monroe County, yeah, me, to be elected president of the State Public Defender Association. A lot of us went on to become judges. Traditionally, this is not a path to the bench. As you can hear in federal court, they're always talking about how I was a U.S. attorney, I was a district attorney. In Monroe County, you needed to be a public defender, sort of. At least it seemed that way. There are 4 common pleas judges, all of whom were public defenders. It's Art on the left, Judge Cheslock next to him, Ron Viken, the lower left, and Maggie Worthington. All were in the public defender office. In addition, the lower courts, the magisterial district courts, there were 4 of us, actually. Me. Next to me is Judge Germano. Below me is Judge Mancuso. That's Colleen. She's here today. And on the far right was a federal magistrate, Bob Lear. I don't think there is anybody on the on the bench now ever in the DA's office. Yeah, and that's who? Oh yeah, that's right. But that's it, and that's very unusual. Now, both Brian and myself are now in the district attorney's office, but not a lot of statewide impact by what we've done here in Monroe County, but a little bit. First was something called the diminished capacity defense. You hear about it on TV shows every once in a while. And basically it says, it's not an insanity defense, but it says mentally you're so screwed up that you couldn't form an intent to kill. And if you have this diminished capacity, you're still guilty, but it's of a less serious degree of murder. Well, in the early 70s, this became a big trendy thing, with psychologists talking about how people you should treat people differently when they go, I'm going to go out and I'm going to murder you, as opposed to somebody saying, I am the Emperor Napoleon and, I have to clear away from my troops. It's just something that, probably not a good example, but. So there's a guy named Walzak, and Attorney Wetmore represented him at some point, and might have even represented him on this case, where it went up to where it turned out, I think, tell me if I'm wrong on this, Mike, but they believed that he had had a lobotomy before this happened, so that you can imagine what that would do to his thought process. And Judge Williams, down at our level, said, well, I can't use this defense because the Supreme Court said I shouldn't. But they should change their minds. And essentially wrote an opinion that said, here's what you should do and why, but I can't do it. And the Supreme Court agreed with him, and it's now by statute, but the whole idea of the defense of diminished capacity came out of a case from the public defender office in this county. And the lawyer who did it here is Mike Wetmore. Another case that came up that required an eventual constitutional amendment was in Pennsylvania, we had what was called face-to-face confrontation with your accuser. Well, because of a variety of different reasons, child witnesses were not coming into court to testify. They would testify in another room or by live video, something we're all used to now with Zoom. But back in 1991, it was unheard of. Bill Sayre, who was a public defender at that time, said face to face means face to face. I get to look at them. They get to look at me. And our state Supreme Court agreed. And subsequently, a constitutional amendment was passed by the voters saying, nah, you can do it by video. I presented testimony to the Pennsylvania Supreme Court Committee on Racial and Gender Bias in the Justice System, talking about unequal funding. And it was part of their report, the story about there's no political impact for me if I give you funding, made it into the report, and the report is gathering dust somewhere. Unionization. This happened after I was gone. It got so bad, it has gotten so bad, that the public defenders decided to unionize. And you think, well, okay, they're rabble rousers. That makes sense that they're unionizing. They unionized with the assistant DAs. Like I said, the county was always very good in treating us alike. Crappily. That's such a word. So, big push was spearheaded by, again, Brian Germano, Mike Ventrella, who's not here, and Jason Leon. At least in the public defender office, they were the moving force behind unionizing. I'm not sure, Mike, do you know who it was in the DA's office?
No,
I don't remember who it was either. Well, anyway, the bargaining unit is the public defenders and the assistant DAs. You know, you tell people in outside of this county that, and they just look at you like you're crazy. And maybe we are. They're Teamsters. And so far, the effect has been the county doesn't offer anything. They always go to arbitration. And the record has been spotty at arbitration. Caseload. I told you how many lawyers there were. It doesn't tell you much if you don't know what their caseload is. If they get 3 cases a year, that's plenty of lawyers. Not so much. From 1998, again, we didn't keep statistics way back when, but from 1998 to the year 2000, you can just get an idea of how the cases went up. From the math, for those of you who are math challenged, there was an 89% increase in cases, almost doubled the caseload. We did not get a single new lawyer. Now they use a different different system for determining caseload. So you can't compare what our caseload was. For example, we went from 248 cases each to 468 cases each. They're using something different now, so it's not apples to apples. But as of 2023, there are 2,200 adult cases, unknown juvenile cases, probation violations, appeals, and other things. That's been the biggest problem, both in the district attorney office and in the public defender office, to getting new lawyers to sign on. The starting salary of $72 is okay. I mean, it's not great, but with the amount of debt they're coming out of, but it's okay. But then they ask, let's take a look at the caseload. And they smile at you and say, see ya. It's just too much. I'm just briefly going to talk about conflict counsel. It's not the purpose of tonight's lecture, but what conflict counsel is remember when I was at one end of the table and Judge Viken was at the other end of the table trying to get these guys to roll over, testify against each other? Well, that's called a conflict of interest. We're in the same law office, the public defender office, and he's telling his client to do the opposite of what's good for my guy, and I'm telling my guy to do the opposite of what's good for his guy. What we now have in that situation is what's called conflict counsel, and there are currently 4, I think.
2.
There's down to 2 now?
Down to 2.
Yeah, and if you think we're
There
public...
are 5 that are funded, but 3 have left. We're down to 2 people.
Yeah.
We're carrying the caseload of 5.
Of 5. And if you think the DAs and the public defenders are underfunded, talk to a conflict counsel. It's almost, it's like going back to the pre-Gideon days. They get paid a certain amount. They got to handle all the cases that come in where the public defenders have a conflict. And they've got to use their own staff.
No offices too. They don't
What?
They have no office. They have
No office, yeah.
Staff, no supplies. They're doing that in their private offices.
Yeah. Like I said, just like the very beginning, they had to do it. Judge Viken, when he was president judge and had to find a lawyer to help out in office, in murder cases we're talking about now, where the death penalty was involved. It was pretty much standard. You had to have 2 lawyers. It was just too much work for one lawyer. And he said he was the loneliest person in the world the day after a murderer was arrested, because he'd start calling lawyers that weren't in the public defender office to help the public defender, and no one would return his phone call. So we have conflict counsel now, and that sounds great, but as Judge Zulick pointed out, you got 2 doing the work of 5 because they're just not paying them enough money.
It's a problem that's going across the board. Is that
Yeah.
we can't recruit lawyers to come to Stroudsburg for some reason. I think maybe because of the debt that people are incurring and getting through law school, they seem to be staying more with the big city jobs where the pay is higher. But last few years, we can't get lawyers to come and take these jobs.
One of the things that was done had nothing to do with me, but when I was president, we were helping to push along the loan forgiveness programs in the federal government, where if you're initially it was just DAs. If you worked for 10 years in the district attorney's office as a full-time district attorney and paid the interest on your student loans, at the end of year 10, your loans were forgiven. And eventually the state organizations for the public defenders banded together and got public defenders in that group. And then the legal aid lawyer said, what are we, chopped liver? And now they're in that group also. But it's 10 years, and it's a pretty good deal, but it's only a pretty good deal because of how ridiculous student loans are. I can't even estimate what. I think if you're coming out of law school, just law school, you're probably coming out with at least $200,000 worth of student debt, student loans. Tell you one quick story of Judge Vike and I was just started as a public defender, fresh out of law school. I had all this stuff, and we're driving to a hearing for a bar fight. So we're driving to this bar fight hearing, and I'm going, Ron, my guy said your guy threw the first punch. He goes, yeah, my guy said your guy threw the first punch. I said, you don't see a problem there? He goes, no problem. Go a little bit further, I'm going, geez, it's, we had ethics class and all this sort of stuff. And I said, Ron, there's a conflict here. He goes, it's no problem. I think I said it one more time, and he was getting a little bit angry with me. I said, no problem. I said, okay, I'm not going to rock the boat. So we get in for the hearing, and officer turns to the judge and says, I'm going to call as my first witness, let's see, I'm going to call Ron's client. Of course, to testify how my guy did it. Ron looks at him, he goes, we're taking the 5th. Cops, you can see the steam start to come out of his ear. He goes, well, now call Muth's client. I'd figured out by then. I said, we'll take the 5th. Cop then turned to the judge and said, what am I going to do if I can't call one of them? I'll lose the case. She goes, you did. Boom. At which point Ron turns to me and goes, no problem. Well, an ethics class would have a big problem with that. But now we've got conflict counsel. And anytime 2 people walk into the PD office and say, oh, we can only talk to one of you. And that's conflict counsel there. We had a couple traditions, not really traditions. They lasted for a while. We had a cookie bake every year where we would bring people in, bake the cookies, and eat the cookies. That was the only rule on cookie bake. Yet you couldn't leave with cookies. Let's see. Yeah, Brian Gaglione, when he had hair. That's Germano, right? Dave Christine. We would have an honorary PD for the cookie bakes. So we would have, sometimes a DA would come in, sometimes we'd have judges come in. Over here, Janet Jackson in the middle. On the far right is Mark Newman, who's another public defender. Joe Doritas, he was a public defender who only handled juvenile cases. The honorary public defenders one year were Judge Miller and Judge Iyer. It's Colleen when she had a very short haircut. Me when I still didn't have hair. Germano's in the background. That's pretty much it. Andy Worthington was briefly a public defender. And I don't know why he was wearing the helmet. Another shot of Jason and his son, I think, at the bottom. Far right is a picture of Dave Christine, former district attorney, Colleen Mancuso, and Mike Mancuso, back when Mike was a public defender. I think that's pretty much repeat of the same pictures. We did athletic stuff, sort of. We would challenge either the sheriff's department or the state police to softball matches. And there's not a whole lot of real good pictures here. It just shows we really did do it. Colleen and I coached a girls softball team. This was who has the best legs, and she won, I think. Every year we had Flag Day, which was a courthouse holiday, and we would go down the river. There are no pictures, and there will be no pictures of our Flag Day trip. We had a band. Band played a couple times. Did the band ever have a name, Jay? Alibi. So they let me sing once or twice. That's me. Mike Ventrell is on bass. Scott Amori is on lead guitar. He wasn't a PD, but he played lead guitar. Wilson, our investigator, was in the back. And Jason, you can see, is on drums in the picture on your right. And just some generic office photos. These are all like 1990s and on. But you can see how nice the office looked. I'm trying to remember, was that before we did the sectioning off or after?
It had to be after. 'Cause
Yeah.
We used to do the back.
Yeah, it was afterward. And there's some more. And young people. Look, the whole bottom line on all this, and it goes for anything in the criminal justice system, it needs money. People talk about how they want laws enforced, or how they want this, that, or the other thing. It costs money, which means taxes go up, and nobody wants that. You want to have a more holistic approach to the whole criminal justice system, more treatment. The district attorney's office has started what's called a law enforcement training intervention or treatment intervention. All of that costs money. That came from the Michigan State Bar, but it's true for every criminal justice system, whether it's public defender or DA throughout the country. Eric Holder, the former Attorney General, put it this way, talking about all the statistics. So, we're almost done. What do I mean by real lawyers? You know, it was a topic of the lecture tonight. Well, the way it works is this, and everybody in here who was a public defender had this happen not once, not twice, but numerous times. You'd be sitting there somewhere with your client, either in your office or before a hearing or after a hearing, and the conversation would go sort of like this. Nothing personal, Mr. Muth, but my parents are saving up money so I can get me a real lawyer. To which I'd respond, great. And sometimes they did, and I was even happier. Look, it's not like a doctor where you go through an internship program and then you go into a specialization. You don't have to be a public defender and then when you grow up, you get to be a DA one day. You know, you have people coming right out of law school, going right in and representing poor people charged with crimes. Or in the DA's office, they're right out of law school, representing victims and their rights when they've been victimized in a crime. It's not a training ground, it's a career. And the people who do it are real lawyers. Like I said, I think I pointed out everybody in here who was one, and asked them to stand up. Give them a round of applause. That includes everybody. Judge Zulick, get up. Germano, Colleen, Mike, and Jason. And as Clarence Gideon said, the only real lawyers, couldn't get one, are those that are trial lawyers. And trial lawyers try cases to juries, which means they're probably in the criminal court, and they're probably in the public defender office or the DA's office. I just put this in there because I had to have something from The Godfather for Mike. It's not personal, it's strictly business. And that was their approach to getting themselves a real lawyer. Here's a listing. I will not read off every name. These are all the people who've been public defenders in Monroe County. I think there's like, I don't know, 70 some. Some people you may never, most people you never probably heard of. That's it. Well, thanks everybody.
Thanks, Mike.
Thank you, Mike. Thank you.